Hello students, welcome to the next video, next lecture. And you already know that why are we here? Because we are discussing the important case studies which are there for CS professional students, and particularly those who have opted IPR as their elective subject. And today we are going to discuss the Anton pillar order which was given, which was the result of the famous case which happened between Anton pillar KG versus manufacturing process. So basically in your book only this much is given, but there is some extra shots, extra points which I have noted down for you guys, so that you can write down and know a little bit more about this particular case law and the reason why we call it as the Anton pillar order, also called as Ashok Kumar order in India and also John Doe order. The plaintiff, Anton Peller KG, a German manufacturer of high repute, discovered that the defendant, Manufacturing Process Limited, an English company, was in secret communication with other German companies. And the name of the German companies, as we are Indians, we have an Indian accent. So maybe there is a chance, there is a possibility that we cannot pronounce it correctly. But the point here is not to pronounce it correctly for your papers, rather to write it correctly. And moreover, this is an open book paper, so you should not be worried whether you will be able to write the correct spelling or not, because anyways you are going to take this printout as well with you in your paper. So basically it is Ferrostal and Hakamoto Rain, right? So basically these two German companies were there, who were being passed on with some secret information, which originally was the secret information of belonging to Anton Piller KG. The defendant disclosed confidential information to the German companies and was negotiating with Canadian and United States firms. Anton Pillar KG faced that the defendant, in cooperation with the German manufacturers, would make a copy of their silent block. So there was a kind of fear in the mind of Anton Pillar KG that because of this secret information being passed on, he was under a doubt, and he had this fear that maybe due to this communication and due to this passing of information, maybe the competitors or the other manufacturers will make the copy of their secret ingredient, secret element, also called as silent block, and will make a presence in the market, which until then was the unique component and unique product given only and wholly and solely by Anton Pillar. And then Penal KG applied for an injunction to restrain the defendant. Now we already know that why do we have the point of injunction? In order to prevent anybody from further damages. And hence, Mr. Justice Brightman granted an injunction but refused to order inspection or removal of documents. The plaintiff appealed, and the Court of Appeal allowed the appeal and granted the order sought by Anton Pillar KG. And hence, this type of injunction, whenever granted under the Patents Act, then it is distinguishedly called as the Anton Pillar order, because after this, a kind of it served as a kind of landmark judgment wherein such type of order refraining or putting an injunction on the person, on anybody who is making bad use of any IPR right, will have to stop the further use of the process or product through which, or through that, because there might be a possibility that there is a kind of harm happening to the person who is actually the owner of the IPR. So in this case, first ever interpellar order were issued. Court distinguished the remedy. Wow, beautiful. Court distinguished the remedy. Just a second. court distinguished the remedy from regular search warrants by requiring serving of orders and the defendant's consent and established the legal framework. This type of order was recognized and given the term Anton Pillar orders as a result of this case. Essentials to be considered while considering issue of Anton Pillar order. The plaintiff, the person who is contending, should have a strong prima facie case or should have a strong prima facie apparent. Prima facie means transparently, which could be seen or observed, or which is so apparent from the records. The potential or actual damage, just now I have told you this to avoid the further possibility of damages or losses. So there is a potential or actual damage being caused by the person who is doing something wrong, and that too of a serious nature. The defendant must be shown to have incriminating documents or items in their possession, and there must be clear evidence that they may destroy such evidence before any further legal action could be taken against them, and the issuance of such order must not harm the defendant or his case. So this is the uniqueness and beauty of this Anton Pillar order, that undoubtedly the um, contention of the plaintiff was taken into consideration. That means a kind of protection was given to the plaintiff, but at the same point of time, there was no harm done to the defendant. And that is the last point which is given. The issuance of such order must not harm the defendant or his case. So this means that a type of equilibrium was sought to be achieved through this Anton Pillar order. I am repeating this statement once again. A kind of equilibrium was sought to be achieved through the Anton Pillar order. ये equilibrium strike करना है. The form of the order makes it plain that the court is not ordering or granting anything equivalent to a search warrant. The order is an order on the defendant in personam to permit inspection. It is therefore open to him to refuse to comply with such an order, but at his peril, either of further proceedings for contempt of court, in which case, of course, the court will have the widest discretion as to how to deal with it. So either you accept it that undoubtedly some wrong or some malicious practice was done by you, and hence you are agreeing to it that yes, don't go for the inspection. We are admitting कि it happened by mistake or inadvertently it happened, whatever might be the scenario or case, but कुछ हुआ. But if you are taking this as your responsibility, defendant in this case, if the defendant is taking at his responsibility that he is not and has not done anything wrong, then the repercussions, the perils of such such a response कि हमने कुछ गलत नहीं किया है, and you can go and take the matter ahead. Now the perils or the hazards of the same will have to be borne by the defendant. Now see the beauty. This is equilibrium. If it turns out that the order was made improperly in the first place, the contempt will be dealt with accordingly. But more important, of course, the refusal to comply may be the most damning evidence against the defendant at the subsequent trial. So basically, if you are not allowing for the search to be or the inspection to be done to the premises of the defendant, then for that you have to have a very strong evidence that you haven't committed anything wrong. But again, it has to be kept in mind that if you are not following the orders of the court, then if you are found guilty of the offense, then it will also tantamount to the contempt of the court being committed by the defendant. So at one place, plaintiff was given the injunction so that to prevent him from the further damages, but at the same point of time, like we have the audio alteram partem opportunity of being heard, यहाँ पे भी relaxation दिया गया, but that relaxation is given to protect the defendant and his case, and also to give some relief to the plaintiff, and hence the beauty of nth and pillar order, right? That's all for this video. That's all for this lecture. In the next lecture, we will be starting with Rajkumar Prasad and others versus Abbott Healthcare Private Limited. A small case, not, I mean, a very complex one, but undoubtedly we will cover it to prepare you for your upcoming exams, right?